Great. So the two topics that I thought we might spend a little time talking about are first, the development of mediation in California and the United States. And then second, I'd like to talk about mediator relations with parties and counsel. So what can a mediator do to establish and build trust with parties and with lawyers? So Lee J, welcome.
Thanks for having me.
It's a great pleasure. And I really, as I mentioned before, I appreciate your flexibility. Lee J did not want to be given a list of sample questions and told me that he was ready to discuss anything. So with that in mind, Lee J, let's begin with the most intimate details of your personal life. And if there's time at the end, we can talk about mediation.
Very well.
No, but more seriously, I'd like to talk about mediation in the United States and in California in particular. And California has an almost mythical status for mediation. It's known as a place for innovation, for excellent training, and for the widespread use of mediation. So I was hoping you could tell us a little bit about how mediation developed in California.
Well, as much as we like to take credit for being leaders, James, the truth is that most of the early mediators here in California went to Texas for their first trainings. And the story goes that the way the standard for mediation training developed in the United States, it's centered around a 40-hour training model to launch somebody as a beginning mediator. And the reason that happened is because when they all went to Texas, the association that was giving the training had reserved a hotel room to do the training in for 2 weeks. And by the time they were ready to come back and confirm, because they had people signed up for the course, there was only 1 week left available in the hotel. So they went from 9 in the morning until 5 p.m. each day for that 1 week they had. And everybody else just copied it and said, well, it was good enough. So Texas was actually the first to start the mediation movement in a very, very strong way. I think where California changed the market and perhaps turbocharged it, really made it grow with excessive speed, was when we introduced it through our courts. The Los Angeles County Superior Court, so the county that surrounds the city of Los Angeles, is the largest court in the world. We have 430 something judicial officers. They started a mediation program there where they started sending cases out to mediation that were in the civil trial courts. So not family law and not criminal or any of the other specific courts we have, but just general civil cases for injuries and business disputes and that sort of thing. And at its peak, that program was sending 35,000 cases a year out to be mediated. And so it was like taking a shot of adrenaline and putting it into the mediation marketplace. And within 5 or 10 years, most of the trial lawyers in the Los Angeles area had participated representing clients in hundreds of mediations. And most of the mediators here very quickly got enough experience under their belts that I had done 500 mediations in my first 6 or 7 years as a mediator because of this pipeline of cases that were being sent out to mediation. So that's really where California launched, was when we institutionalized it and connected it to the court system. In my mind, that's a little bit late for mediations to occur. Once a lawsuit has been filed, the litigation has begun, and then they're sending them out. It lends itself to more of a settlement discussion of a lawsuit more than the kind of mediation we might rather like to do as mediators.
Right. Great. I'd like to speak more about mediation in California, but you mentioned that the roots were in Texas. Do you happen to know how mediation got started in Texas? Why there was this mediation culture in Texas?
Boy, I don't. And I couldn't even tell you who taught those first courses because I came along myself about 4 years later. So that was about 30 years ago. And I don't even know who did them, but it's deeply steeped in their culture there as well. but I don't know the genesis, unfortunately.
So the program that you mentioned with the courts, that was ultimately stopped, is that right?
After 17 years, the court system, the state really, ran out of funds to support the number of clerks that it took to operate that kind of a program. Just the sheer paperwork alone required a tremendous budget for the folks, for them to send that many cases out to mediation and track them. And so eventually they had to cut it for budgetary reasons. But by that point, our private mediation marketplace had taken off and was vibrant and thriving, and was fully capable of supporting all of the litigated cases that needed to go out to mediators.
Great. In the article I mentioned before in the Los Angeles Business Journal, you talked a little bit about JAMS. So now that we're focusing more on private mediation, could you say a little bit more about the role that JAMS has played in the development of mediation in Los Angeles?
Yes. So JAMS is one of two national providers of significant size in the United States. JAMS is privately held at this point and is owned by their own mediators. They have a group, I couldn't tell you how many, 30 or 40 of their mediators who are shareholders in JAMS. And it is the most successful private for-profit organization in the country and has a large presence in Los Angeles. The other national organization is the American Arbitration Association, which has an international ICDR, the International Center for Dispute Resolution is their international branch. And they are the largest dispute resolution provider in the United States overall. But they were set up 90 years ago as a nonprofit organization. And so they're in a different conversation than JAMS, even though we mediate and arbitrate side by side, sometimes in the same buildings. But those are the two largest national providers. Then in California, we have a very specific culture, especially in Los Angeles and Southern California, that's geared around, we call them ADR provider organizations. And in a sense, they're sort of like agencies like JAMS and the American Arbitration Association, but they're smaller and regional and really catered to Southern California or all of California. And between all of the regional and national organizations who supply mediators to the marketplace, they probably control 80% of the private ADR marketplace between arbitrations and mediations. There are very few independent mediators remaining in Los Angeles because most have joined one of these organizations, like joining a real estate agency. If you're an independent realtor, most of them here belong or associate with a bigger agency, a company, a brand name. And that's kind of how the mediation world has worked here in Los Angeles. It's rather unique, I think. I don't see this in most of the rest of the United States to the same degree of market dominance that they have here in Los Angeles.
Great. That's interesting. And so going back to the distinction you drew between JAMS and AAA and its international incarnation, what's the difference in the way those organizations operate? Because I know from AAA and the ICDR that they have, for example, mediation rules, and they're involved in case administration. Does JAMS offer similar services?
Exactly. I don't mean to make JAMS sound like copycatters because they're a very innovative company, but they really followed the model of AAA, the most important of which was hiring a national marketing team to go to all the large corporations, the national and multinational corporations, and have JAMS written into the arbitration clauses of these big companies' contracts, the same way the American Arbitration Association had done years before that. And so those two dominate the marketplace in part because they are the stated venue for arbitrations, and they are either the venue or the rules that guide mediations coming out of those larger companies. So yes, the model, the business model is almost identical. And the fact that they're for-profit and non-for-profit is invisible, I think, to the public. I think the public just sees them as providing mediators and arbitrators to the marketplace.
Great. And what types of cases are being mediated?
It's a great question, and it's changed over time. It's changed largely because of the numbers and types of cases that are filed in our courts. So California is very trendy, and so in the early and mid 90s, and actually through most of the 90s, there was a lot of personal injury cases. So car accidents or construction sites where people are injured and sue the owner of the property or the owner of the vehicle to recover for their damages and their injuries and their lost work and things like that. So we call that personal injury, and it was the overwhelmingly dominant number of cases that were in our court system that were being sent out to be mediated, or mediated because the court had such long delays that people wanted quicker resolution and went to mediate them sooner. In about the mid to late 90s, employment cases became very popular, and right now those, I think, are the ones that are being mediated most of all. Most of my colleagues are mediating almost strictly employment cases, which is where somebody feels that they're discriminated against in the workplace or harassed or something like that unfairly and sues the employer either while they're still employed or more often after they've left their employment there. And those are the cases that are really flooding the mediation marketplace right now.
And what's the profile of a typical mediator, if there is one? What's a typical background for a mediator in Los Angeles?
That's a great question. So we have, I would say, 3 different categories of mediators in the marketplace. So I'm gonna compare the marketplace to the mediators as we talk about them, because the answer, like in most mediation questions, is it depends. So why don't we start with the marketplace? There's the marketplace for litigated cases where they're represented by counsel. They have filed a lawsuit. They're starting the litigation process, or they're deep into the litigation process. And those kinds of cases tend to attract look for a certain kind of mediator to mediate those cases. Then there are cases where you have a major corporation and 2 vice presidents aren't talking to each other and can't get along, and the company is almost stagnant because they can't work together fluidly, and they'll bring a mediator into that workplace or into a hospital to mediate between doctors and nurses, or nurses and patients and families and that sort of thing. So in those internal kind of mediations, where they're not in a court, but they're working within an environment like a hospital or a company, they tend to seek out a different kind of mediator for those cases. So that's sort of how the market divides. And then the mediation community, you have, and I think this stretches throughout Europe and most of the rest of the world too, we have one segment of retired judges, people who have sat on the bench, decided cases, retired, and launched a private career as arbitrators and often mediators. You have attorneys who have represented clients in litigation, who know the court system and the litigation process and can speak and are hired to speak very strongly about the probability of a case's success at trial and how evidence will come into play and all those sorts of things, how a jury or a judge might interpret a contract. So they're very what we call evaluative in their style as mediators. And then you have non-attorneys who are business people and hospital CEOs and folks like that who are not attorneys, but who come from more of a business world. And I guess in that non-attorney pool, I'd also say you have psychologists, you have couples counselors who mediate divorce cases and family situations and things. So those are sort of the 3 categories that I think we can break the community of mediators into, and then how they match and where the demand is for certain kinds of cases becomes really important.
Mm-hmm. Great. And you just mentioned that at least in the last category, that evaluated mediation is common. are there any other features of mediation in Los Angeles? I'm thinking, for example, about the use of private sessions versus joint sessions. Are there any other characteristics?
So yes, because the number of mediations so I wrote an article called The Funnel of Mediation, talking about how in the shape of a funnel, at the very, very bottom, you have disputes that are very well, they're compressed and clearly defined, and they're reduced to legal causes of action with legally allowable damages and so on. And those are done typically in this very evaluative style and tend to look at the economics of a case and the risk tolerance of the parties, but really what the probability of outcome is, and tries to gauge that. And again, with an evaluative kind of style. As you move further up the funnel, the way I described it is you move from there up to, let's say, workplaces and hospitals like we just talked about. And then you move even further up to divorces and families, which can affect every single person walking the planet, not just those who are in litigation or in an institution. And finding those, and this is where you have disputes in churches, or you have a board of directors of a company who's not getting along, or has a shareholder dispute or something like that. But it's the things that all of us go through in our conflicts all the time. A neighbor wants to build a bigger house that blocks this neighbor's view, and things like that are all kinds of conflict in all kinds of areas. So the further you move up into the funnel, the more mediation opportunity there is, but the harder it is to find those people. If you go to the courthouse, mediators tend to go, we say, like ants to a picnic, and just flood to the courthouse, because that's where the cases are that are already formulated and defined and easy to find and mediate. So in those more legal settings, we tend to find not just a lot, but almost exclusively private sessions. There's a culture and a trend here in Los Angeles that comes from the lawyers who represent the clients, who don't want the face-to-face of a joint session. They don't want their client to say something that they can't control or edit, or they don't want somebody getting too upset. They don't want to have to argue with the opposing lawyer when they feel like they have to correct something. It gets too argumentative and tiresome, and unless it's really done well by a mediator who's very skilled at conducting that kind of a joint session, it can do more harm than good. And I have found that it only takes, for a particular lawyer who represents clients in a mediation, they only have to have 1 or 2 bad joint sessions before they swear them off and say, never again, I don't want to have a joint session. I'd rather sit comfortably in a separate room with my client and coffee or tea and a snack, and then you, mediator, go back and forth and do your shuttle diplomacy. Right. When we're in the workplace space, or we're earlier in the litigation process and people aren't as entrenched, there we can do more joint session work and clear up understandings. We exchange more information in a joint session, which is important early in a lawsuit or before a lawsuit. But once a lawsuit is a year down the road and everybody has read every document and every email and all the witnesses have testified on the record, everybody knows the case. So the benefit of a joint session is oftentimes reduced just because the information's already out there.
Right. So you're of course based in Los Angeles, but your practice is quite national. So I imagine that you have some familiarity with other parts of the United States and how mediation is practiced. The United States is a big country. I'm sure there's a lot of variety. But are there generalizations you can make about how mediation is practiced, for example, on the East Coast or even in Northern California,
Sure.
ways that it might be different than Los Angeles?
Yes, very much so. And before I start, I feel like I should apologize to our audience. I feel like I'm talking in paragraphs this long every time I open my mouth, and I apologize for the length of my monologues, James.
No, it's
but
great.
there are, thank you, but there are many differences in how mediation is practiced around the country. The single largest difference, I think, revolves around how confidentiality is treated around the mediation process. California was the first and continues to have the most stringent protections of confidentiality in a mediation process. So people can come together and theoretically say whatever they want to say and know that it won't be repeated later and used against them. To be really clear, we call it confidentiality, but it's not. What it actually is here is inadmissibility in our courts. So if you and I, James, are in a dispute and we go to mediation and I say, yeah, I know I sold you something that really wasn't very good, but so sue me. If you can't go to court later and say, but Lee J admitted he sold me bad goods, because that happened in the mediation and it's protected and it's inadmissible. But you can go tell every other one of my customers, and the confidentiality that surrounds mediation doesn't prevent that. So it's really inadmissibility that we call it confidentiality. But we've had 5 or now 6 cases go to our state Supreme Court, our highest court, to challenge the confidentiality of the mediation and try and breach that confidentiality to find out what was said. And all 5 of those have stood every single time in favor of protecting the confidentiality and the inadmissibility of our process. The flip side is, in Florida, for example, there's a very famous case here in the States about a gentleman who made videos called Girls Gone Wild and would go to college campuses or where people, the kids would go for spring break and drink too much and get wild and crazy. And he would shoot pictures of attractive girls getting crazy and sell these videos. So he was a bit of a raunchy guy to start with. But the story revolves around a mediation he went to where the judge ordered them to go to mediation. He participated in the mediation. He was obnoxious and inappropriate. You can Google the story or look it up online. But he showed up in shorts and like a Hawaiian shirt and flip-flop shoes that he kicked off and put his bare feet up on the table. I mean, he was disrespectful in every imaginable way. And we know this because when they went back to the judge, the other side was allowed to testify about his behavior in the mediation and quote him and tell the story, and it all came out in open court. So that was in Florida, clear across the country on the East Coast, and a very, very different treatment around confidentiality, at least in that case. So confidentiality differs state by state. And what's really interesting as we sit here on this Zoom platform, and we're all in different places, you all around Japan, and me, of course, here in Los Angeles. If this were a mediation, we would have cross-jurisdictional conflicts between how each of the different places that each of you are sitting might deal with mediation confidentiality. And that's the latest conflict we're dealing with now, because we're in a place where mediators are accessible anywhere because of Zoom. And I've traveled before to do mediations all over the country, as you mentioned, and we tend to either adapt the local confidentiality laws, or I bring the California ones with me and everybody agrees to be bound by those in advance of the mediation. But now we have people all over the country and all over the world doing Zoom mediations, and it requires more discussion and more agreement on what confidentiality is going to govern. And then, of course, there's the issue that you can't contract to keep information from a court. So the question, I think, is, can you opt into California's rules, which make the discussions inadmissible? Or would they say, sorry, this didn't, you all weren't in California when this took place, so I, the judge, want to know everything that was said in that mediation. So the confidentiality thing always interests me because it's such a fine line, the weighing between the need for justice and for the judges to have information to make decisions, and the need for privacy for us to be able to go behind closed doors and say what we really need to say to resolve the dispute and have the sanctity of the mediation process that protects that. So it's a delicate balance. Other things involve the other biggest difference, I think, between the states here in the US is in Los Angeles, everyone who's on this Zoom call right now could say, I'm a mediator, and you would be. There's no barrier to entry in the profession. There's no certification. There's no anything that you have to do before you can call yourself a mediator. There's a typical 40-hour course like we talked about that gets one entree onto court panels and private panels and things like that. But you don't even need that if you want to walk down the street and hand out business cards that say I'm a mediator. In Florida, you have to be approved by the Supreme Court. You have to have had Supreme Court approved training courses. You have to have people vouch for you, I think. And there was a time where only attorneys could be mediators of court-annexed cases in Florida. And they've since overturned that, I think wisely, because I myself, you said I've been doing this 26 years now, and I've done 2,500 mediations, most of which were in the litigation process, and I'm not a lawyer. And so I can practice here in California. There was a time where I couldn't practice in Florida. So it's an interesting marketplace in that regard. Florida is very, very regulated as to what they can and can't do. And in California, we're almost unregulated. It's a different marketplace. What's it like in Japan?
In Japan, and I should probably defer to my colleagues because they could tell you much better than I could. But the little that I know, I'll share. Court annex mediation is quite common, but the form that court annex mediation takes is quite different from international mediation in various ways. For example, the parties meet to do the mediations for a short amount of time, and there's a long break between each of the meetings. Just from that perspective, it's a very different process than the process that I think that you engage in.
Yes, ours tends to run in one very long session. We come together at 9 o'clock in the morning, and I've had dozens of mediations that have gone straight through past 2 o'clock in the morning. I had one that went all the way until 6 or 6:30 in the morning, 21 straight hours. So it's a very different process.
Incredible, yeah. Great. Something else that I wanted to ask you about, I imagine that your practice, just being in Los Angeles, is by nature very international because it's a very international city. But I'm wondering if there's a growth in international mediation. And what I mean by international mediation, I mean the parties are located in different countries, or maybe there's an international dimension to their business dispute. Is that growing in Los Angeles?
Yes, it is. The business cases that I see very often involve business that's transacted internationally. And it's funny, since the worldwide pandemic, the COVID-19, we've all been sort of locked down, and so mediators have started using Zoom as we are now, like it's a new phenomenon. But gosh, for 15 years, I've been using FaceTime and WeChat and all sorts of different platforms to have people by video, again, oftentimes for 10, 11, 12 straight hours on the video camera while we're mediating back and forth. And I'll go into one room for people who are here in Los Angeles, and I'll go into the other room with a lawyer in California representing the board of directors or the family or whoever it is, the landowner or something in China or somewhere else, and have them on the video the entire time. I've had people from all over the world, from all over Europe and the Middle East and everything, participating virtually in our mediations for as long as I can remember. And yes, it's because there's so much international trade in Los Angeles that, and even within Los Angeles as a city is such a diverse melting pot. We're not the most diverse. I mean, I think New York and some other cities, even San Francisco, have more diversity than we do. But we have, so my office used to be situated in a part of Los Angeles fondly called Koreatown. because it was where all the Korean folks who've come over to Southern California all live sort of together, and all the markets and the stores and the signs on all the buildings and the restaurants and everything are all in Korean. And I'm told that we have 1 million Korean residents, Korean nationals living here in Los Angeles in that area of town, and that it's the largest community of Koreans living outside of Seoul anywhere else in the world. And so my office was right in the middle of that neighborhood, and I was mediating with Korean parties and Korean council, and oftentimes having people remotely, from Seoul and other places, involved in those mediations all the time, constantly, like almost daily.
Great. Well, that's a really good segue, because the other main topic I wanted to discuss with you are the more human dimensions of mediation, in particular how mediators can connect and how they can build rapport with lawyers and also with clients. We've just had, as I mentioned before the call, a couple of very interesting interviews, really about policy, mediation policy, and about mediation procedure. I've read what you've written, and I've watched you in interviews, and you seem to have a very natural way of connecting with people. So I thought that we might talk a little bit about that. How do you approach building rapport and trust with lawyers and with parties?
So the first thing I have to say is, I think the thing that gets in the way of that the most is mediator ego, intentionally or unintentionally. I think a lot of mediators think that this is their process, or it's about them. And to be really callous, we shouldn't matter that much. And I think there's one of my early trainers was the president of mediate.com for a long time. His name was Jim Malamed, and he said the mediator's mantra is, it's their stuff. It's their stuff. And it was a constant reminder that I learned early in my career that it's not my case, it's not my money, it's not my feelings that are hurt. So what I do before I go into every mediation is I vessel and go in as an empty teacup and let them fill it. And I go in with curiosity. My concern about evaluative mediators being able to do what we're talking about is that sometimes they're so focused on, they've read all the briefs and they've read all the case law and everything. They're so focused on what they know that their approach to the mediation seems to be, let me go in and impart information. Let me ask questions to try to build rapport, but really I'm just waiting to tell them what I think about their case because I've read it and I have an opinion now. For me, I read the briefs before I go in, and I try to put myself in the shoes of each person. And I try to say, if I were this person, how would I be feeling as this event went on? Whether it was a contract breached or an accident that happened or whatever, how would I feel going through that? How would that affect me and the people around me and my life? And how would I feel walking into this mediation, not knowing what's going to come of it, and knowing that it might be my big day, and knowing also that it might be a very long, frustrating day without a positive outcome. And the same if I'm the defense. If I'm coming in there as the insurance company or the big corporation, and I feel like the person on the other side is making a frivolous claim, and I feel bad that we're actually going to be tempted to pay them something because it is actually less costly than if we go and prosecute this at trial or defend it. So I try to put myself in their shoes and how they feel when they walk in. And I find, especially in separate rooms in private caucuses, again, whether it's virtual or in person, I find I'm often speaking different language in the two rooms or more. I find I'm speaking different tone and different pace, because for me, it's about meeting the parties where they're at. I did a medical malpractice case one day where a widow sued a doctor who cared for her young husband. He goes complaining of chest pains. The doctor treats him and says, I think all of your vital signs are normal. I don't think you're having a heart problem. But when I press under your arm, you wince with pain. I think you pulled a muscle. So I'm going to give you muscle relaxers as a prescription and send you home. And the guy went home, took the muscle relaxers, and had a massive heart attack in the middle of that night and passed away. So his wife is suing the doctor. And as I went to that mediation, I had them in separate rooms for the entire day because there was a lot of animosity between them. And there would have been nothing good that would have come at the beginning anyway from having them both in the same room. I went and I sat with the widow who was crying hysterically and accusing the doctor in the other room of killing her husband. My tone of voice, my pace, where I was with her, I was all but sitting knee to knee with her and just trying to empathize with her and trying to give her the courage to get through the day because it was so difficult for her. And I walked down the hall into the other room, and there was a doctor, the doctor's lawyer, and the insurance adjuster for the doctor. And the three of them were in that room, all in business suits and very proper. And my language in that room was very legal. It was a little more judgmental. And I look back and think that was an unfortunate moment, an unfortunate choice on my part. But at the time, I approached it that way. And I was very matter of fact about the case and the probability and the outcome, and how are you going to overcome telling a jury of your peers that he came to you complaining of chest pains, you treated him, and he went home and had a heart attack anyway. It's going to be tough for you. And so my language, as I went back and forth up and down the hallway between the two rooms, had to change my tone, my presence. My presence had to be authoritative in the doctor's room, and it had to be very gentle and empathetic in the widow's room. And I don't mean to make it sound like we're actors, but we have to meet the people where they are. And that's one of the benefits, I think, of having them in separate rooms, is you get to join them in their space. And I think that's whether we're doing it virtually by Zoom or walking up and down a hall. A thing I've noticed is with Zoom, the moment of transition, as I click out of one breakout room and into another breakout room, it's instantaneous. I'm used to having 45 seconds to walk along hallway and shift gears and get my mind, shifted to go talk to the next people and think about what I'm going to say when I walk in there. That mediator's moment to kind of prepare ourselves for what we're going to do when we walk in and be intentional about it. And with Zoom, I have to be careful not to just click into the other room and, have it be so sudden, because it requires more of us, I think.
I think that's fascinating. It's something that I've read you writing about this, about the way that you adapt the approach that you take to the specific person and to this specific case. So I thought we might try a little exercise. I'd like to introduce you to hypothetical people involved in a mediation. And I'd like to hear your thoughts on how you would seek to engage these people on a human level. And of course, people are very complex, and these examples are a little bit stereotyped, but let's see how we go. So let's imagine you're the mediator, and the first person is Michael, and Michael is a party who's come to you who does not seem to want to engage in the mediation process. Maybe Michael is there because he has to be. Maybe there's a provision in a contract that says he has to try mediation first before he can go to court or before he can go to arbitration. So how would you engage with someone like Michael?
So I tend to engage with questions a lot. So I would start with, so Michael, it seems like maybe this isn't what you'd rather be doing today. And you want to role play Michael? You want to be Michael?
Sure.
All right, good. All right. So it seems like this isn't really what you want to be doing today.
No, I don't see the point. We've already had negotiations. We've gotten as far as we can, and I'm ready to start the litigation.
So what is it about the litigation that you're looking forward to?
We're going to win. We have a very strong legal position, and we're going to win.
Okay. And so we would talk some about the length of time that would take, about the cost, about the uncertainty and how long he's going to live in this uncertainty. And then if I can build enough comfort level with you as Michael, I might drop down into, so let me ask you this, being in this lawsuit, how is this affecting you? How's it affecting your family, your home life? Talk to me about that.
Mm.
And how long do you want that to keep going?
Mm.
Is there any benefit on that front to us getting some closure today?
Mm.
At which point Michael will usually say, yeah, my wife's been after me to get this done, but I just don't want to quit, something
Right.
like that.
Right.
And so we have that discussion, and all I really want to understand is what it is he's so interested in.
Yeah.
And if this process and participating in it actively could bring some closure, not that we're going to do anything to him, but that he gets to decide, he gets to say, no, I'm not doing that, but if you'll do this, then I might consider it. Having that ability to invest a couple of hours or whatever it's going to take, and know that he can say no to whatever proposition's on the table at the end of the day,
Mm.
or he can say yes. And if he says yes, it's only going to be because he sees that as a better option than the litigation that he's looking forward to. And we're going to have that conversation. And really, it's kind of a trust me kind of a conversation. And I can say to him, look, I can imagine how you're feeling sitting here today and knowing with all the confidence that you're holding that this isn't going to resolve your dispute today.
Mm.
Here's the challenge. I'm sitting here today also looking at you, knowing that after 26 years, I've seen so many people walk in the morning like you've walked in this morning, and seen them walk out at the end of, at the end of the day, knowing that they got satisfaction and they feel good about it, and the weight's lifted off of their shoulders. And I see that often enough that I have a different experience when I look ahead of us today than you do when you look ahead of us. So what I'd love to ask is, will you give me a chance to try and make this experience more like the one in my mind, and hopefully less like the one that you're holding in your mind? That kind of a conversation.
That's great. Let's maybe we can try another.
Sure, who's next?
So now we have Tito. Tito is a party in mediation. You're the mediator, and you feel that Tito may be a little too accommodating to the other side, and Tito maybe in your mind is maybe giving up too much in the mediation. Is that something that you engage with Tito, or do you not see that as your place? How would you approach that situation?
Let me just ask into the question a little bit more.
Sure.
Giving up too much in what way? Like, I think the case is worth more, and if he held out, he could get more? Or too much in that he said at 9 o'clock this morning, I'm not settling for less than 100,000. And if he's the plaintiff and now he's suddenly ready to sign a deal at $18,000, right? Which of those kinds of settling for too little are we talking about?
Right. Probably not the one that's just about the money, because I think I could anticipate your answer to that. But if you feel like over the course of the day that all that you've learned about the case suggests that really Tito has interest, and Tito is not pursuing his interests enough. Maybe it's not only money, but it's other issues. Is there any way to address that, or do you think that's just not the place of a mediator?
Also, is Tito represented by counsel, or is he there by himself? Because that makes a big difference.
Maybe you could shed a little light on both situations, if you don't mind.
Good. So the temptation, if he's there by himself, the temptation is for a mediator to let their own bias come in the middle of things and say, gosh, Tito, have you talked to a lawyer about this? And maybe even do things like when Tito says, okay, I wanted this, but I'll be willing to give that up, and I give this up, and I give this up too. Some mediators might say, are you sure you want to give all that up? Which is a subtle way of letting their bias come out. I say, what I do instead, I take what people want to do and I help them accomplish it. Because one of the things I know really well is that they don't tell us everything. nobody walks into my mediations in Los Angeles and says, I swear to tell the truth, the whole truth, and nothing but the truth, and takes an oath. They don't tell us everything.
Mm-hmm.
Tito could be about to lose his house to foreclosure because he needs the money desperately, and this is going to save him. I don't know. He could have um, a wealthy relative about to pass away and leave him millions of dollars, and this is really just something he wants to end.
Right.
But so what I'm going to do during the mediation is I'm going to say, so Tito, let me just make sure I understand what you're saying right. You want to give up this and give up this and give up this, and you just want to ask them for this. Is that right? Do I understand that right? So I want to check for accuracy, and I want him to hear it back from me. And if he hears it back from me and says, yes, that's what I want, then that's what I'm going to go in the other room and explain to them. And near the end of the day, if it is just money, because it's easy to measure, so we can talk about that here. If he says to me first thing in the morning, I'm not taking less than $100,